Introductory at NCA's Guide.
Okay, so good morning, good afternoon, good evening, depending on where you are. My name is Funto Omotoso. This call is being recorded for Canadian Professional Responsibility, the NCA Guides Introductory class. I'm really happy that you could join me here. Successful, hi, your mic is on. Would you like to do a brief introduction?
Yes, good evening.
Good evening, how are you?
Okay, my name is Hector. I'm fine, thank you.
Okay. What part of the NCA journey are you?
Well, I've just myself the compulsory science courses, so I'm about to prepare for PR for February.
Perfect. Okay. So quite a lot of people on the call are taking PR as their first class or their first exam for the NCAs, which is a good way to start. It's one of the less content-heavy courses. And it's pretty similar to your jurisdiction back home, wherever you're from. If you're from common law jurisdiction, it's very similar to your common law jurisdiction ethics. So Canadian Professional Responsibility is also referred to as professional ethics. And it's one of the core courses for the NCA qualifications in Canada. So what we're going to do with this class is I will speak to you and ask you questions, but I will try to run through the whole syllabus. Try to explain what parts I think are important in the syllabus, how you should go about reading it. I know that quite a few of us are doing it for the first time. So the first thing I would ask is if anybody is aware of because it's one of the things you will see constantly, the IRAC method of responding to questions. Is there anybody on the call that wants to answer that?
Yes, I'm familiar with that.
Okay.
In university, that's how we're taught in terms level. Oh, this is how you answer questions. So how we're taught is that the I stands for issue, R is rule, A is application, and then T is conclusion. So when you do have a fact pattern, you have to identify the issue, then the applicable rule to that issue, then you apply the rule to the fact, and then you make your conclusion. That's how I understand IRAC.
Perfect, Abby. So with the Canadian system, if you weren't trained or taught in the Canadian system, you do have to learn how to use IRAC. It's a basic analysis tool. They want to be sure that the information that you're gaining you can apply it to daily life or apply it to a real life case or apply it to a real life client. So basically, the issue is they want to be sure that the question they're asking you, do you understand what they're asking for? So you would search for your issue that way, the question that's being asked. The rule, obviously, is obviously in Canadian Professional Responsibility and criminal law. They're the only ones that use codes out of the courses that are being studied. So we do have a model code that has all the rules relating to professional conduct that tells you these are the rules in Canada, this is how they're applied. So basically the rules section is asking you what rules have you studied that apply to the question. The rules section also applies to your cases. What cases apply to this area of our subject? So when we discuss the areas going forward, we'd be able to pick out like major areas in the syllabus. And then the application is okay, fine. So I've actually picked out the rule. I know what they're asking for. What are they saying about it? What does this concept say? And then what is my opinion? Obviously, they want to know your opinion about it. And then your conclusion, obviously. So these are things that we will definitely deal with in the last class, which is open to everyone to join, even those who are not part of the intensive classes. So you can register for the exam prep. So after you read and study through the intensive classes, there's an exam preparation class that teaches you how to apply the information that you have learned to the questions and how the NCA expects you to respond to their questions. First of all, what you would require to study Canadian Professional Responsibility is the official textbook. Not sure if you can see it. So the official textbook. It's Lawyers, Ethics and Professional Regulation by Alice Woolley, Richard Devlin, and a few others. You would need some sort of summary notes. I know the NCA Guides has Mano Akishola summary notes for sale on the website. You would need your model code. So the model code, as I said, is the code that is listed. It's free, so it's online for download. It's not anything that you have to purchase. If you go to the FLSC website, FLSC is the Federation of Law Societies Canada. It's a joint federation of all the law societies and all the provinces in Canada. So they have the model code on their website. So it's easy to Google search and download it. I would advise that if you have any sent to you, any copies sent to you, I'd advise that you re-download what is the most up-to-date one. The NCA announced in advisories, I think last month, that they will be updating the PR syllabus. It has not been updated yet. So we will definitely have class with the old syllabus. The last one was changed August 2019. We would work with the old syllabus. If it does get updated before February, of course, we will update as we go along. But I think it's a little late for them to update since they know that people are already studying for class, okay? Download the model code at the start of the syllabus. So maybe I should start sharing my screen so that you can see exactly what I am referring to. So the syllabus for the Canadian Professional Responsibility course is available on the NCA website. So nca.legal is the official website. You go there, look for schedules and outlines. You should get your syllabus there. You should be able to download that. Right now, we're working with, as I said, the August 2019 syllabus. And obviously, it tells you what to download and what you need to study. I've already mentioned that you do need the textbooks. You do need the model code, like here is written here, and you also need the edited cases. So the Trinity Western and the Goya case, the Trinity Western and the Goya cases were added to the syllabus, I think 2 years ago, and they've added the edited version. So basically, when you're studying with the NCA, a lot of these courses or cases reoccur. And what happens is when you read Goya or Trinity Western, it applies to different parts of Canadian law. You can use them for different courses. So what they've done is they've edited the versions that they've attached to your syllabus with the information that is required for this particular course. So not all the ratios, not all the decisions are applicable to PR, but they've edited it and given you the information that you need specifically. You can see the courses or the cases, sorry, on Canly. It's a free resource that you can sign up on to read cases if you want to read the full courses or the full cases that are available for you in your syllabus, okay? Obviously, if you're registered with the NCA for an exam already, you would have access to LexisNexis. So they give you access to LexisNexis a few months just before your exam so that you can check the cases that are there. Okay, so let's go into the syllabus and try and explain. Let me try and put you through what the full syllabus is saying. Does anybody have any questions before we go into that? Any questions? I noticed that Rashima joined after we had done the introductions. Would you like to introduce yourself? Tell us what part of the NCA journey you are at.
Hi, I'm Rashima Gordon. Hi, everyone. I'm actually just starting studying, to be honest. Okay. Yes, but I do plan to take the exams next year.
Okay. Have you done any NCA exams?
Not yet, no.
Okay, perfect. Welcome to class.
Thank you.
You're welcome. Okay, so let's go straight into the syllabus. Hopefully at the end of this class, you would have more light shed on the course itself, understanding what the course is about, and basically understanding how to go about reading it. So the first part of professional responsibilities, part A, they've divided the course into 4 parts, part A, B, C, and D. It's an easy way to understand how the course is structured. Part A is kind of the pardon?
I was going to ask something or mention something about the syllabus being changed. I think one was changed last week or 2 weeks ago, and the exam is in January.
Administrative, is it constitutional law?
I think so. A friend of mine mentioned that she was already studying and was almost ready for the exam. And then it got changed. So that means until at least 3 or 4 weeks to the exam, you are not sure that the syllabus will not be changed.
Well, they changed it in November, believing that you have a full month to study. But from what I've seen from constitutional law, luckily, the information wasn't changed. The information was rearranged. So we've done a review of the constitutional syllabus, and we noticed that the information was actually moved around. It's not like there's any major addition. Exactly. And most times, for example, 2 years ago when they updated the professional responsibility syllabus, they added language rights. Language rights is already in the model code. So if you've read your model code, it's something that is already there. It's not new information, but they added it to the syllabus, so it's actually listed. So I was like, if you were reading anyway, you would have come across language rights already in the past syllabus. But let's see what they're willing to or planning to change in this PR1. I don't think it's going to be anything major. Another thing is if you've been studying already, because the model code hasn't changed, the textbook hasn't changed, you still are studying the same information. So if they do end up changing it before the exams, it will just be an addition. It won't be anything major.
That's what I've been working with, believing that if I'm reading the model code
exactly
and the guide, at least I showed up. I'm not reading the textbook. I think it's scary. So,
do you have notes?
Yes, I have Manuel. I have Lyran. I have Vanessa, but I think it's ended up slowing me down because I keep going back to compare what this person said to that person. So I'm considering sticking to one of the notes and the model code.
So one of the things I'd like to advise everyone is please download your model code. The first thing, please read it like a storybook. Don't make notes. Don't try to gather information. We're all lawyers, so I understand that everybody already understands how to retain knowledge. I would advise that you take your model code and you run through it from start to finish. Basically, the model code, I can show it to you on the screen, is a bunch of rules and a bunch of commentaries. So the Canadian Model Code, Canadian Professional Responsibility Model Code, it's got rules that you abide by, which we all understand from ethics in our own provisions or in our own jurisdictions, but it also has something called commentaries. Now, from when we get to the syllabus and we're discussing sources of Canadian professional responsibility is not just the model code. You can also get sources or get information from cases, right? You can get information from disciplinary decisions. So if somebody has been reported to the Law Society and they come up with a decision, it's also a source. And there's some other documents as well that are in the syllabus that I'll point out that you can get as sources of Canadian professional responsibility, okay? Now, the thing about it is that they've added commentaries because they believe that they've given you a line of a rule, but you might not understand what that rule is about. Okay, so the commentaries now expand on that rule. I think we'll look at 3.4 towards the end of class, and we'll look at what the commentaries say in 3.4 because it expands on the meaning of that rule. So for example, if they say something like don't have close intimate relationship with a client, then the commentaries explain what close intimate relationship is. So is it having a sexual relationship with that client? Is it actually getting married to that client? Is it getting married to the family members? Things like that. So the commentaries expand on the rules so that you have a better understanding of what the rules are saying. Because I know a few people wonder whether they're supposed to be writing the commentaries in the exams. No, you're supposed to be writing the rule. The commentaries are just supporting information to help you understand what that rule is about. Okay? So do go through the model code. That way, when you're reading the notes, like Yewi pointed out, it's a bit confusing when you go back and forth. When you're reading the notes, you know that you've seen that rule before in the model code and it's nothing new. You're able to apply it and say, okay, this is what the notes is saying. It's referring to the rule I've already read. Okay? Okay, so let's go straight into the syllabus. Let's see if we can run through that and then we'll take questions and then try and understand the rest of the syllabus and see if there are any questions that anybody has. Okay, so the first part of Canadian professional responsibility is the legal profession, lawyers in the society, and the society of lawyers. Okay, one thing about our syllabus, which is different from everybody else, is that they put issues to consider in the syllabus. So basically, these are issues that they want to know that at the end of studying, they want to know if you can answer these questions. Those questions, for example, is what is a profession, what is public interest, things like that. The purpose of part A is for you to understand the foundation of professional responsibility. When you understand the foundation, you understand the concepts, and it's easier for them to build up on the other parts of the syllabus. So basically, part A talks about ethics itself. You can't understand professional responsibility without understanding what ethics is. So it goes a little bit into the Aristotelian, the philosophical aspects of the course and tries to explain that to you so that when you're going through the rest of the course, it's understandable. Okay. Part B, which is basically the client to lawyer facing part of the syllabus, talks about the client-lawyer relationship. So the way I divide it in the intensive classes is by explaining that the client-lawyer relationship has three parts: the beginning, the middle, and the end. So the formation of the contract, when is the relationship actually started? When does the relationship begin? When do you consider that a relationship is built? Then obviously the middle, how do you treat a client when you're in a relationship with that client? What happens if there's conflict of interest? How do you keep the information confidential? And all those things that have to deal with the relationship of the client and the lawyer. And then obviously the end of the contract. What causes termination? When can you rescind? When can you leave a contract? There's a common one. For example, if you are an organizational lawyer, known as an in-house lawyer, and you work for an organization, and you believe that there's fraud being committed, for example, how do you know that? How do you pull out yourself from that contract? So there's something called reporting up the ladder, which we will see also in the intensive classes, which basically is that once something has happened in the organization that you believe to be fraud, you report it to the person that you're most in contact with in that organization. If that person doesn't respond, you report up the ladder. So you report to the chief legal officer, it doesn't respond, report to the CEO, report to the board. And obviously, if you report and nothing is being done to resolve the issues that are being faced, then you're allowed to pull out from the interaction. You're allowed to pull out from being the representative of that organization. So you can terminate the contract. So part 2 talks about conflict of interest, competence. It talks about things like confidentiality and privilege, the differences. Part 3 goes on to explain, part B. So part A, part B, part C, part D. Part C goes on to explain specific areas to consider, practice areas to consider when you're talking about professional responsibility. So a negotiator, when you're a corporate counsel, when you're a government lawyer, and part D is access to justice. Okay? I will go into part A specifically now, and then we can discuss part A. Has anybody who's read, I know Yewi has started reading. How did you find part A when you were reading it? What were the issues? Did you face any issues when you were reading that section?
Yes, I found it quite dense at first and quite theoretical.
Yes.
But as it went on, reading manual really helped me with that. I think it made it a bit simpler for me And then also, I actually enjoyed philosophy in school.
Oh,
so when
great.
we got to the models of Kantianism, utilitarianism, and what does the most good to the most people, all those, it became more interesting. So I think at first it's a bit dense. I would suggest maybe after you just try to pick up a notes first for this one and read it through the notes. I think it was quite dense at first until I actually picked up the notes to read, especially manual. Manual made it way easier.
Oh, he would love to have that feedback. I'll let him know.
Yeah, I had a question concerning that aspect though.
Okay.
Can an exam question come from those alternative, blah, 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 dominant and the rest?
So what with PR specifically, not with other NCA courses, PR is a storytelling course. They need to know that you understand the concept. They would ask you a question. They wouldn't ask you a question about the dominant part of professional responsibility, but obviously they will expect you to refer to it. So understanding that dominant aspect, maybe you're trying to explain a scenario, or you're trying to explain the concept of competency, or you're trying to explain the concept of professionalism. Of course, you refer to the dominant method of ethics, or dominant method of understanding the course. So nobody's going to ask you a question about it specifically. So if you read, for example, Trevor C. Farrow's article in part A, he explains the dominant role, and he goes about to explain all the other alternatives and then gives a postulation on what he believes we should carry out. Okay, since we're in part A, we can discuss it basically. The dominant role that success is asking about, it's an understanding of the different types of ways that lawyers interact ethically, or lawyers interact with their clients, or lawyers interact or carry out their services. Now, this dominant method is basically saying that we know that the way law is structured, the person in charge is usually your client, right? So you understand that your client's objectives and the things and the requirements that your client asks for is what your lawyer is going to do. So in the olden days, it's still quite dominant right now, but not as much as it was. Before, your client is all and in all. Your client is king. Your client is everything, anything they want. You have no say in it. You have no input. You just have to do what the client says. It was believed that because the client is the paying person, the person that's actually paying you to defend them or to represent them, it was believed that everything they said was basically raw. So if the client says, this is what I need you to get done, the lawyer does it without request. So if you imagine a mafia boss or a mafia family, they always had like a lawyer attached to them. And it didn't matter what the mafia family was asking the lawyer to do, they would obey. Okay, there's a case that's always referenced in the notes and in the textbook. I think it's Queen Catherine, or one of the wives to the King of England. She was supposedly, he wanted to divorce her because she was supposedly in an affair. And she hired her lawyer. And everybody was like, why would you represent somebody who is supposedly seen as doing the wrong thing? And it was mentioned in that case that the client is king, that everything that you must do as a lawyer must be in correlation with what your client wants. So when Trevor C. Farrow was writing his article, he was saying that the dominant rule basically is that even when we watch films, for example, you're watching Suits, you can see that the client is king. Lawyers are staying in the law firm till late hours in the day. They're doing what the client's bidding. Sometimes they're representing criminals. They're not looking for they're not trying to find justice. They're basically just representing the client, looking for loopholes and trying to get them off. Okay. But he was now suggesting that we should go after the sustainable method, that we shouldn't just look at the client, that there are other factors that we should consider, like public interest, like justice, like other lawyers. He pointed out that lawyers are actually, what do you call it? They're pillars in the society. So you should look at the society, you should look at the other people in the society, you should look at public interest. There are other things to consider when you're practicing law. It's not just that dominant method of the client is in charge, right? So the sustainable method that he was proposing was that there should be a work-life balance between your representation of the clients and everything else that you have to consider. Sometimes he was talking about you considering even your, even though it shouldn't influence it, but you have to consider all the other things before you make a decision. If your client, for example, lets you know, this is something you also see in the notes, lets you know that maybe he has a bomb strapped to his chest and he's going to harm people in the society, you definitely have to be able to balance that and not just say blindly, I'm supporting my client. Okay? Success. Did I answer your question before I diverted? Did you understand that?
Yes, you do.
Perfect.
Perfectly. Thank you so much.
Okay, fantastic. So Trevor C. Farrell's article is something that I think you should actually read. It's part of the syllabus. It helps you to understand that basics and foundation of the course. It helps you understand where law is coming from and where it's going to. So we can see that it started with just obeying your client. The client is all and in all. Client tells me to do this, I go ahead. But obviously you have to now start in the 21st century, realize that lawyers are people too. And also realize that lawyers also need to have that work-life balance. And they're not only work-life balance, but lawyers also have to consider the fact that they're purveyors of justice. They have to uphold the law. So there's so many other things that you have to consider, not just your client's opinion. He now also suggested, which is really important to note, because in your conclusion when you're writing the exams, you have to be able to conclude and say, this is my opinion, this is what I think, but what are the cures, what are the solutions? So professional responsibility is a lot about curing an issue. Okay, so his cures was saying that I'm fine, I'm proposing this sustainable method of practicing law, but I'm also thinking that you guys should start teaching it in law schools. You start teaching it to students. If we start teaching it to students now, they're already growing with that mentality so that when they get into the practice of law, it's something that they've learned and they imbibe and they bring into the practice of law. We know that it's not as easy to change the system that is established right now, because obviously as a student, you get into the practice of law and your principal partner is telling you, oh, you have to pay your dues because I paid my dues and I slaved and I worked and I'm now where I am, so you have to do that. Okay, but no, we're saying that the students will go into practice knowing that they need to balance it out. The client is not the most important factor. There are other things that should be considered as well. So also note those in the article. I'd say that highlight the things that you would like to, if you print out the article for the exams, highlight those things that you would like to lift if you have to refer to it. So like Success pointed out, they're not going to ask you a question about Trevor's article. But when you're referring to or talking about something in professional responsibility and you realize, oh, this sounds like a dominant model, this sounds like a sustainable model, I can suggest a sustainable model here. You can suggest and say, according to Trevor's article, these are his suggestions, I agree with them or I disagree with them, and this is how we should go ahead. Okay, so that's how you pull in his article into the exams. It's not like they're going to ask you a question specifically about it. Okay. Now in part A, we were saying that part A is very heavy. It's very heavy, it's very dense. So let me see, most of the things, it talks about ethics. The first two things that you should note about ethics is a body of laws, like the model code. And ethics is also your interaction as a lawyer with your other with your clients, with other lawyers, interaction basically in your day-to-day practice as a lawyer. Okay, so it's two things. It's the body of laws, which is, for example, the model code, and it's also your own interaction with these in your day-to-day practice as a lawyer. So it's not just, oh, professional ethics, rule 1, rule 2, rule 3. It's also professional ethics. You as a lawyer, what would you do in this situation? Okay. So now we realize that, okay, obviously in the practice of law, there are issues that might arise that wouldn't be seen as ethical. Okay. When you become a lawyer, especially in Canada, the Law Society and the body of benchers are allowed to look into not just your public practice and your service to your client. They can look into anything, even your personal activities, as long as they feel that it brings disrepute to the profession of law. So they can look into any ethical thing that they feel might affect the practice of law negatively. So basically, their job is to ensure that law continues to subsist. And if you do something that makes the public see you in a negative light, it will show negatively on the profession as a whole. And obviously, if your client doesn't trust you, your client doesn't trust the lawyer, they're not going to want to come to you or any other lawyer to pay money, good money for representation, right? So basically, anything that casts a negative light or casts an aspersion on the profession, the Law Society or the body of benches or the disciplinary panels that review these things would be able to look into those particular aspects and evaluate whether you've been an ethical lawyer or not. Okay, so it's not just public activities, it's not just representation of the client. Sometimes they can look into they've given them powers to look into your private activities as well. And I've explained why, because they don't want it to cast a negative light on the profession. Now, the first part of the course talks about professions and professionalism, right? The first thing you need to understand about a profession is the fact that professions have been elevated. So they're not the same as careers, they're not the same as jobs. You can get a job in a bank as a teller, you can get a job in an HR department. These are all careers, but they're not seen as professions. Now, the professions, example, law, medicine, and a few other careers, are seen as self-regulating careers, self-regulating jobs, self-regulating interests. So basically, for you to be in a profession, one of the things that is important to that profession is the fact that they're self-regulating. And what does that mean? It means that they are the experts on their members. They're the ones that if their member carries out anything negative or anything wrong, they're allowed to discipline their members personally. Nobody's going to send you to the police. Nobody's going to send you to another panel. It has to be a panel of the members of your profession. Okay? So if they say what is a profession, for example, one of the things you note about a profession is the fact that it's a self-regulating body. Another thing you note about a profession is that there are loopholes and there are things that you need to jump and things that you need to do to actually be seen as a member of that profession. So, for example, with law and medicine, you need to go through particular education. You need to go through particular exams. You need to pass some particular courses before you're seen as an expert in that field. With a profession, you're supposedly seen as an expert. A lot of professions affect the public. So it's not just, oh, it's a one-on-one interaction. No, most of the members of the profession actually affect the public and the society at large. So if a person comes to a doctor to be helped, it's a life and death situation. If a person comes to a lawyer to be helped, of course, that is, I could get locked up forever, or I could get be sent to jail for something wrong. So basically, the profession is trying to help. It has public interest at heart. Okay. There are quite a list of things that you would see in your notes and your textbooks regarding professions and professionalism. And it's important to just bullet point those things when you're reading. So if they ask a question and you see that the question is talking about a concept like professionalism, you have your bullet points ready and you know the things that you're going to mention and you're going to list when you're doing the exams. Okay. Does anybody have any other questions or any questions so far with what I've said? Because I can't see your faces, so I have to keep asking. Sheson, Lyle, Rashima. Yes? No?
No question.
Yeah, I don't have any question.
Okay, perfect. So we'll go straight ahead. Okay. So when you're talking about ethics, and now we're going to talk about the foundation of ethics, there are different views of ethics as a concept. Before you understand professional responsibility, they try to explain ethics to you specifically. These different views of ethics come from when, like the Aristotelian views and all of that, when the philosophers were discussing ethics and building it up and coming up with the information and doing the research, okay? So the different types of ethics or the different views of ethics, for example, we have virtue ethics, we have utilitarianism, which can also be called consequentialism. We have the Kantian and the deontological theories of right action, okay? And we have the postmodernism and we have pluralism, okay? Those are the different views of ethics. Now, virtue ethics, just like the name says, talks about the virtues of human character, right? It says that human character, we already know what is good and what is bad. We know what virtues are, and we base our ethics on those virtues. So it looks at human character, practical judgment, orientation. It looks at the flourishing of the human race. How does the human race grow? How can we help it grow, right? It presupposes that everybody knows what's good and bad, right? You know what is a vice, you know what is a virtue. And because you know what is a virtue, your ethics are based on these virtues. So your decisions are based on knowing what's right and what is wrong. Okay, so for example, you as a lawyer know what is important, the importance of things like competency, loyalty, honesty, compassion, justice, that the only way you can serve your clients is if you understand these virtues and you carry out these virtues or you exemplify these virtues. You know that somebody committing murder is wrong, and as such, you would know that your representation of that person, sorry, I'm admitting someone into class. Your representation of that person would have to be in the aid of justice, right? The next view is the utilitarian view or the consequentialism, right? Utilitarian view of ethics. It implies that humans maximize what they want in their own self-interest and would do so based on their own rationality, okay? That there's no real basis of right or wrong. It's based on the person's self-interest. That everybody has basically their end goal. This is what I want. And basically, I would carry out my ethics based on getting to my goal. So if your client comes to you and says, I would like to achieve this purpose, for example, it's utilitarian ethics actually believes that that person is going to do everything in their power to maximize that basic goal or that self-interest. Okay, so the utilitarianist view, in a simple nutshell, it says the greatest good for the greatest number. So if we want to make a decision and there are 400 people in our society, if our decision is going to be beneficial to 250 people, that decision is not right or wrong. That's the decision we're going to go with. Because it's the decision that has the greatest good for the greatest number of people, right? The self-interest of the society or the self-interest of the maximum number of people is what we're going to consider. Okay, so basically it says that you as a lawyer, or you as an agent, you're a neutral factor. You're not looking at anything as right, you're not looking at anything as wrong, you're just looking at the basic self-interest of the society. Okay, now the Kantian also called deontological theories of right action. This basically says it's a strongly rule-based belief or view of ethics, that there's a universal rule for what morality is and what morality requires. It believes that you as a human being, you as a lawyer, you have a capacity to reason, and this capacity is what helps you with your decision making, okay? That you have a freedom of choice, and your freedom of choice enables you to decide what to do, right? Now, the morality of your actions isn't based on whether it's right or wrong, again. So unlike virtue ethics, where everything is either right or wrong, we already know what is right or wrong, it's based on a set of rules that exist. So if there's a law in a society, the law is what you're going to follow. Whether the law is right, whether it's ethical, whether it's wrong, it's just rule-based. This is what the rule says, this is what the law has established, this is what we're going to follow, this is what we're going to obey. So obviously people who are part of that view don't really care about things like, is this good in my heart or is this good as a person? It's just, what does the law say? This is what the law says, this is what we're going to obey, this is what we're going to do. Okay? If the law says, for example, do not torture, right? It means you cannot in any circumstances torture. That's what the rule says. Even if the rule says something that even personally you believe is right, or you believe is a good thing, and the law says that you cannot do it, then you will obey under that view, that ethical view. You will obey what the law says. Okay? Then we have postmodernism. This says that the world is unknowable. What is happening right now, or what is being built, or what is occurring is based on a person describing it. A person cannot be separated from his desires or impulses. So if you have an impulse to do a particular thing, that is what your ethics will be based upon. Your ethics won't be based on following rules or maybe what society sees as good or bad, but basically you would sit down and evaluate it and analyze the situation as a human being, and then you would actually function based on that. It's based on individual judgment. So unlike where we say that it's for the greater good for the greatest number of people, where you're looking at the society as a whole, with postmodernism, you're looking at just one individual judgment, right? You're looking at that individual's judgment and what that individual says, and usually it's based on that individual's analysis of the situation they are in, right? And how they carry out or how they function based on that situation, based on their own impulses, based on their own desires. So if you were a judge, for example, and you were coming up with a decision, you would not be looking at the society or the morality or the rules. You would be analyzing decidedly based on your interaction with your society or your interaction with the decision or the facts at hand, and you'll be making up your decision based on that. So it's basically focused on individual judgment, right? And then there's the last one, the last ethical view, which is pluralism. Pluralism says there's no correct logic. So the views that we have discussed or spoken about just now, there are multiple values, multiple ways of identifying what's important. So you have to consider all these different things. You weigh and measure the different values. You weigh and measure what's right and what's wrong. You weigh and measure the beliefs of the society, the greatest good. You weigh and measure what you yourself are seeing and analyzing. So it involves the practical use of judgment. So with pluralism is saying that you can evaluate various different things, weigh and measure different things, and come up with a decision. The reason we're looking at these views of ethics is so that you understand where each person is coming from. There haven't been any real questions in professional responsibility in the past couple of years actually speaking to any of these particular types of ethics, but it's good to understand it. It's good to know it. It's possible you could get, because the NTA has been changing their systems recently, you could get a question that asks you about professionalism or law as a business, and you can refer to this as ethics, the ethical views, So you can talk about the fact that ethics is not just a body of laws. Ethics is also how you react to these laws. There are various views, but then it also depends on how much time you have per question. If not, you can mention them, but you don't have to explain these particular concepts. Okay? Obviously, in part A, we're going to review cases like R and Neil, Law Society and Jabor, Canada and R and Murray. Law Society and Jabor is a advertising case. So I think in most common law jurisdictions, when we talk about advertising, advertising is strictly frowned upon, right? But in Canada, it's you can advertise as long as it's within a certain framework. It's within a certain body of rules. As long as you are not the one calling yourself an expert, as long as you are not trying to force a particular group of people to purchase your services, as long as you're not lying, there's strict set of frameworks that you can advertise within. Aaron Jabor is a case where the guy had actually proposed that he was the best lawyer to be used for middle-income families. He was achievable, or he could be hired by middle-income families. He realized that a lot of people thought the lawyers were expensive, and because of that, they didn't come to the law or come to lawyers for services. And he was trying to fill that niche. But it was seen that what he had done was unethical. And the disciplinary panel actually punished him for that, for carrying out those activities or for putting up that advertisement in the first place. So we talked about self-regulation, we talked about law as a profession. There's a part that talks about law as a business or a business of law. It talks about stuff like, should you focus on law as a business or should you focus on it as a lawyer? And the conclusion at the end of that discussion basically is that you have to balance it out. You have to carry out your activities as a lawyer, first of all, but you also have to understand the practice of a business. Law is a business. It has to function as such. It has to generate funds and money for you as the practicing lawyer, for you to be able to carry out your activities, okay? It does talk about regulation of lawyers and regulating of the law profession. If you're still looking at my screen, it talks about the role and the responsibilities of law societies in the governance of the legal profession. This is where we talked about how intrusive can they be? Is it just your public activities or your personal activities that they can look into? What are the responsibilities of the law societies and how do they govern us? And obviously, I mentioned self-regulation and how the law societies can regulate its members. Okay. It talks about, part A also talks about education, good character, requirement of practice of law, competence, a very important concept with professional responsibility, the competence of a lawyer. If anything you are about to do with your client does not exemplify competence, then you should not do it. So that's one of the rules that are in the model code. If anything that you're carrying out, you're not competent to carry them out, then you should not carry it out. For example, language rights. The rule in the model code states that if you cannot explain to your client in the language that they fully understand what you're about to do for them, then you cannot represent that client. You are then obligated to find a lawyer who can handle that client and explain everything that is about to happen or will happen in the language they fully understand, right? So that's what language right covers. So basically, if you look at what I said about language rights, it also affects competency. So if I cannot give my clients services in the language they understand, that means I'm not offering competent service. And if I'm not offering competent service, I'm not being an ethical lawyer, and I can't carry out that activity because it's against the ethics of my profession. Okay, I hope I'm not confusing you. Are you guys still fine with where we are at?
Yes.
Yeah.
Yeah. Okay, perfect. One of the required readings is the case that was attached to the syllabus, the Trinity Western University and College of Teachers. Now, in a nutshell, the TWU case, in summary, Trinity Western wanted to establish a law school, and Trinity Western is a Christian university. So they wanted to establish a law school, and so in deciding whether they could establish a law school, they needed the confirmation or the approval of every province, the law society in every province. So they had gotten the approval of, I think, 7 out of 10 provinces. And when they got to British Columbia, in reviewing their documents or their application, realized that they had a stipulation that they would be taking, I think, only Christians, and that the policies of the school were against the LGBTQ society or the LGBTQ community, okay? And they were saying that they can't let a law school exist that had limiting factors or that was discriminatory, that wasn't diverse and inclusive, okay? So the Law Society of BC declined approval, and Trinity Western couldn't go ahead with the law school. Now, the questions that surround this case basically are that how much can the Law Society impact your decisions? How much can they delve into what you do? We know for a fact that it's a Christian university. We know for a fact that, what do you call it? We know for a fact that it's a Christian university, and Christians have their own values and beliefs, and they have their own belief system, and they should be able to come up with their own policies for their own schools. So how much can they look into your actions? How much can they regulate your actions? What powers does the body of benchers have? So the discussion around this case and professional responsibility basically is how much can the profession or the society impact your activities or decide how you carry out your own activities. So those are the things you should be looking at when you're looking at the facts of the case and you're looking at the judgments. And then you're supposed to come up with your own decision or with your own belief in that case, so that when you're explaining it or giving it as an example, you're giving your own opinion as well. They don't just want you to get the information and pour it. They want you to be able to analyze the information and apply it to whatever they're asking you for. Okay. And then there are further optional materials that you can read. You can read your law societies, the LSO Protecting the Public, Law Society of New Brunswick and Ryan, LSO Paralegals Online, the Constitutional Act. These are just things that they want you to refer to as you're reading, so that it's not like the professional responsibility is functioning on its own. It's still attached to all the other laws like the Constitutional Act, okay? And obviously, it would be good for you to look at the province that you're in and look at the provincial laws or the provincial ethical laws that apply to you specifically. The NTA wouldn't ask you specific questions to a particular province, but it's good for you to know. Okay. So part B, like I said earlier, if you joined late, part B talks about the relationship between the client and the lawyer. So we've gone through all the theoretical aspects of PR. We've talked about ethics as a concept. We've talked about self-regulation, the business of law, and now we're coming to the practical aspects of professional responsibility, right? The title of part B is Ethics, Lawyering, and Professional Regulation, okay? The first thing that you're going to discuss there is the lawyer-client relationship. And like I said earlier, the lawyer-client relationship has 3 parts, the start, the middle, and the end, okay? Now, the start is talking about formation of the lawyer-client relationship. The middle, like I said, like the middle that I'm referring to is the relationship itself. And the end would obviously be terminating that relationship. How can you terminate? When can you terminate? What is expected of you before you can terminate that relationship? Now, parts of that you will be discussing when talking about formation of a lawyer-client relationship. One of the reasons you need to know when this relationship begins is because it affects confidential information or information that you need to keep confidential for that client. Okay, so when you're talking about formation of a lawyer and client relationship, let me ask you before I go ahead and explain. Let me see. Lyle, when would you say a lawyer-client relationship is formed? I've been the one speaking all the while. It's an introductory class, but let's see what you guys feel.
Sorry, I'm not home, so I'm not being able to. Your question.
Oh, yeah, so I was saying, when do you feel a lawyer-client relationship is formed?
I feel at the point of at the point of offer and acceptance.
Okay.
Okay. Like if a lawyer, if a client walks up to a lawyer and says, "Oh, I want you to represent me in this matter," or the lawyer agrees, and they probably agree on fees and the other terms of the lawyer-client relationship. So I feel like if the lawyer offers and the client, if the client offers, lawyer accepts, and the lawyer presents a counter offer and says, "Oh," and the client.
You're breaking up a bit.
Hello, can you hear me? Hello.
Yeah, you're breaking up a bit, but
Hello.
it's okay.
Yeah, so I hope you heard me. I said they got
yes, I did.
Hello. Yeah, I said if they get to a stage of offer and acceptance, then the relationship, a lawyer-client relationship can be said to have been formed.
Okay, perfect. Anybody else want to try before I explain? Anyone?
Okay, from what I've read. Okay, is someone else? Because I know I've spoken earlier. Is someone else talking?
Yeri and Rashima. Yeri, go ahead,
Okay.
and Rashima will talk after.
Okay, so the belief here is that once the person approaches you with the mind of telling you anything that tends towards, okay, I'm thinking of getting a lawyer because so and so and so, and it can be at any point, anywhere, social gathering, as long as person approaches you and says, "Oh, I'm looking for a lawyer, I'm considering this, that." Like if somebody says, "Oh, I'm considering getting into a contract with somebody to supply something. This is what I want to supply. This is how much I'm getting it and everything." Once the person gives you a background information and says, "Okay, so I'm thinking of getting a lawyer," whether you guys agree on terms immediately or not, as long as person has told you and you have the knowledge, you have a relationship.
Okay, Rashima.
Yes, I was saying that the attorney-client relationship, yes, it concerns receiving information from the client, but it also goes a bit further in terms of there being an acceptance of an agreement. So if you have a retainer or letter of engagement involved, then you would see where the lawyer-client or the attorney-client relationship has conceptualized.
Okay. So I would say naturally, if you're looking at contract law, you would say that the lawyer-client relationship started or was initiated at the signing of, like Laya said, offer and acceptance, the signing of a retainer. But with professional responsibility, because we have to understand or discuss concepts like confidentiality, the lawyer-client relationship starts before the signing of a retainer. And like Yeri said, and she's been reading, information that is gathered when you say, "I would like you to be my lawyer," is considered as well when we're thinking about the ethical aspects of representing a client. Okay, if it was a contract and nothing is signed, then we can say, well, there's no relationship formed yet. But in considerations for ethics, because of the concept of confidentiality, prior to signing a contract or signing a retainer, you're seen to have started or formed a relationship, or there's a formation of the lawyer-client relationship earlier than signing the contract, and I'll explain why. So if, for example, you work in a law clinic and a person has come to you to see if you would like to be their lawyer, they obviously would bring to you information and they have to explain to you what it is they want to be done before you agree and say, okay, fine, let's go ahead and I will be your lawyer. Now, that information that you have gathered from that client is considered as confidential information. There's a whole part about confidentiality and privilege, and we'll get to that. Now, confidential information is information that you have to keep confidential, if I want to use the same word again, for your client, irrespective of whether your relationship is terminated or not. You have to keep that client's information or that particular type of information confidential for the entirety of your life. So any information that happened in the discussion between you and the client before you sign that retainer is considered confidential information. And since you're obligated ethically to keep it private, then your relationship has already begun, even though nothing has been signed. Okay? So what I'm saying is that for formation of the contract, it's not specifically the offer and the acceptance. The formation of the relationship can happen prior to signing of anything formally or signing any document formally. Okay. We'll still talk about confidentiality. I don't want to jump the gun here. So that first question with issues to consider says, when does the lawyer-client relationship come into existence? We've discussed that. What choices are available to the lawyer with respect to accepting clients? That's going to be in the notes, and that deals with do you want to accept somebody whose beliefs clash with yours? How neutral are lawyers supposed to or expected to be? Can you turn somebody down because you believe that maybe your religious beliefs don't align? Things like that. Okay. What's the significance for the lawyer? So basically, like I said in the beginning, there are issues to consider in every section of your syllabus. And after you've read that particular section, it makes sense to come back and look at the issues to consider to make sure that you are actually on top of the information that you need to know for that particular segment. Okay. So we've talked about lawyer-client relationship and the formation when it comes into existence. Rule 1.1-1 of your model code commentary 1 states that a lawyer-client relationship may be established without formality. That's also part of what Yebi was talking about. And I was saying that when I told you that you should go through the model code, these are the parts of the things that I would like you to note as you're going through the code. So basically, you're going through the model code, you're reading the commentaries. The commentaries explain what the code is saying, right? Let me see what 1.1-1 says specifically. So rule 1.1 is the definition section of the model code. I think it has 6 definitions. Has definition of conflict of interest, definition of competency, definition of what a law firm is, what a lawyer is, and it defines the word client, right? So in defining the word client, it gives commentaries below that, and it states that it's a relationship established without formality. Representative capacity doesn't make you the client. Client is the organization. Okay, so that commentary is talking about client as an organization. There have been some questions in the past from the NCA where they would tell you the CFO of an organization comes to you, the lawyer, to ask you specific questions, And towards the end of that question, they'll mention something about the CFO saying that you are their personal lawyer. And here it's saying that no, just because you were answering questions to the CFO doesn't make you that person's lawyer. You're the lawyer to the company, the corporation, or the organization, and your relationship with the CFO is your relationship with your client, the organization as a whole. So you giving advice to the CFO doesn't make the CFO your client. Okay, so that's what the commentary 2 talks about, representative capacity. That just because someone is representing an organization, the organization is not, the person is not your client. The client is actually the organization itself. So if, for example, the CFO steals money and hides documents and tries to take documents away, the person you should be protecting is the organization. The person you should be protecting is the partnership of the corporation. You should be trying to protect that partnership or corporation from that CFO who is committing fraud, because your client in that instance is the organization. Okay. And then the last commentary, when talking about the definition of a client does not include a near client. Okay. There has to be evidence that the client has reasonable expectation that a relationship was created, not somebody saying that, oh, I have this issue and I would like advice, and you give advice, but because you're a lawyer, the person then says, oh, the advice you gave me, you're now my lawyer. No, I gave you advice, objective evidence, or gave you advice in passing, doesn't mean that we created a relationship. You didn't come to me to offer services and all of that. Okay, so basically the code has defined what the client is, which is the rule, and then gives you commentary, like I explained, gives you different commentaries to explain that rule, to make sure that you are not misguided when you're reading the rule itself. Okay.
Sorry, I had a question.
Okay, go right ahead.
So you know how like we've established that once like you doesn't have, have to wait. Sorry, that's my nephew.
Okay.
Jaden, I'm coming. So you know how we've established how you don't have to have that formality to retainer. But in that situation where the client has divulged information that is confidential, so he also probably has to intimate in a way that he needs your services, because now you know this is your last explanation where, for example, you're just giving advice. So in that first scenario, even when he has come and said, oh, I'm doing this and doing that, and has divulged some confidential information, he should also intimate that he wants to retain you, as against just asking for like a general advice.
It's not a passing conversation. It's not, oh, we were at a party and then you said, oh my gosh, I stole money and I'm not sure what to do. And then at the party, you, Abby, then say, oh, do you know what? I think this is how you should go about it. He hasn't come to you for legal advice. It was a discussion. Your ethics doesn't cover that at that point. They can't ethically hold you at that point because he hasn't come to you in seeking for legal services or legal advice. But the model code advises that when you do give that kind of advice, business advice in court, that you mention specifically that this is not a legal opinion or legal advice. This is just business advice, or this is just passing advice. It does say that in the code. So this person, that's why I said my first statement was they came to meet you at the legal aid clinic. They are actually looking for services. The end game, they want you to be their lawyer. And obviously, in getting to that end game, they now speak to you and offer you some information for you to be able to evaluate whether you want to take on the case or not. In that instance, we know the end game is formality. We know the end game is signing a retainer. We haven't signed it yet. But if they take you to a disciplinary panel, you can't say, oh, we never signed the retainer, so I didn't think what he was telling me was confidential, so I shared it with my best friend.
Okay, I see.
You've already taken that information. We know that it's a client-lawyer relationship is what we're looking at forming. But I took this information prior to forming it. That information remains confidential. Let me give you an example of a case. So the difference between confidential information and privileged information is a legal concept. It's backed by courts. You divulge privileged information, they take you to court. Confidential information is ethical. It's an ethical concept. You divulge confidential information, you go before a disciplinary panel. They can't take you to court for confidential information. Okay? Manual's note actually has a table differentiating between the two. Privileged information, because it's legally backed, we have a matter at hand and we're about to deal with this matter. So you have given me documents and information for me to handle this matter, right? Once the matter is dealt with, you've paid me, I've carried it out, I've finished it. Privilege ceases. It's no longer privileged information. I'm no longer bound to protect that information. Okay, it usually has to do with litigation, court matters, maybe contract matters. There's a start and an end of the retainer. Confidential information is any other information that you have come across while dealing with this client. So usually I say have a visual of two circles. The big circle is confidentiality. Inside confidentiality, there's a smaller circle, and that's privilege. And in the instant that the matter at hand ends, privilege dies. You're no longer, there's no longer any obligation for you to keep that information privileged. Okay? So the case that would be discussed, let me give you the facts of that case in the syllabus. Oh no, it's an example where a guy came for a labor matter to the lawyer, right? And he discussed with the lawyer, and he says, and in their discussions, he mentioned the fact that he had issues with his wife. Okay, but it was a labor matter. So obviously he also brought labor documentation, maybe employment contracts and all of that to go ahead with dealing with the contract or dealing with the matter at hand. Now, those documents and information are all privileged information. The instant the labor dispute is resolved, that privilege dies. I don't have to keep that employment contract privileged anymore. I don't have to keep that information private. It's not up to me anymore to hold that information private. But the fact that he has issues with his wife, which is confidential information that I gained, I take that to the grave. It's not anybody's business for me to share that this man has issues with his wife. Now, what happened in that instant case is that the wife was the receptionist of the lawyer. So the instant he heard that the wife and the man were having issues, the lawyer starts to date the wife based off the confidential information that he gained during working with the man. And the disciplinary panel found him guilty and said, no, you cannot use a client's confidential information to your advantage. It's confidential. So not just sharing it, the fact that the lawyer actually acted on it, yes, was also seen as unethical. So you can't take him to court for that, but you can report him to the Law Society.
Okay, thank you.
So the formation of that contract, it's not, oh, I gave you advice in passing as a friend. The formation of that contract is the end game is a lawyer-client relationship that we're trying to build. And I got some information along the way. So I know that that information is confidential, but not, oh, my best friend is a lawyer and I was just giving you information and I asked, oh, you should have kept that confidential. There was no relationship formed. Like commentary 3 states specifically, how did the commentary put it again? The commentary put it as in passing, right? Yeah, not a near client. That's the word. So it wasn't. You weren't trying to form a relationship at any point. Okay.
Okay.
Thank I help?
Yes.
Perfect. Perfect. Okay, so going back to our syllabus. Yeah, so we already dabbled into confidentiality, the preservation of client confidences. And this section talks about lawyers' obligation to the client, the ethical features required. Please note that these are not legal requirements. These are not things that you can be taken to court for. They are all ethical issues. So if any of these are contravened or any of these are broken or breached, you'll be reported to the Law Society, and a disciplinary panel will be the one that overviews it or tries to evaluate whether you are right or wrong. Okay. Sources of the lawyer's obligations, legal ethical features of the obligations, circumstances where exceptions to obligations have been established. Okay, one thing I always mention to students is the fact that professional ethics is not saying that you can't do anything wrong. Professional ethics is saying that at every point in time as a lawyer, you can and will make mistakes. Okay. Now, the model code has been created in such a way or in such a fashion that when you make these mistakes, there's a cure. You're always trying to cure the mistake that you made. It's not every time, you're not God, so it's not every time that you're aware of the mistakes and you go ahead and know that there's a mistake. You wouldn't know at every single point that there's something being done that you're not aware of, right? Or that you've done something wrong. So the model code has been established in such a fashion that every time there's a breach, most times there's a cure, right? So even when you're writing your NCA exams and you're talking about concepts, you say, okay, this what they're talking about right now is formation of a contract, or what they're talking right now is client confidences. Okay, in the scenario they've given me, is there any breach? Oh yes, there's a breach. When you're doing your analysis, you're not just giving them the information about that concept. Like if you're talking about client confidences, for example, or confidentiality, you define what it is, you list how it's different from privilege, you give a list of items, it's ethical, it's not legal. You now say if a lawyer breaches the duty of confidentiality, he can cure it by blah, 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 blah. Okay, he can cure it by, for example, with conflict of interest is more defined. With client confidences or confidentiality, there are usually exceptions to the rule. So in Canada, what I've noticed, or what we've noticed in practice, is that every time there is a rule, there are usually exceptions to that rule. So for example, when you're reading confidentiality or you're reading about privilege, privilege is actually not a topic under this course, but you do have to know the difference between confidentiality and privilege, which is why they bring it up. Okay, and you should point that out. If you're going to deal with anything dealing with confidentiality, you point out that, oh, it's different from privilege by blah, 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 blah. Okay, now the exceptions is that, for example, if you're supposed to keep something confidential, the rule is a lawyer shall keep blah, blah, blah information confidential. But there will not be a list of exceptions like the public safety exception. Like I said, if a client of yours, for example, has a bomb strapped to his chest and tells you as a lawyer and is working in the mall, you can't keep that information confidential because there's a public safety issue. So there's a public safety exception. To preserve the people in the public or the society, you have to report that information to the police so that your client can be stopped. There are also exceptions of fraud. There are also listed things that you should note when you're reading this part of the syllabus. Okay. The other important aspect under here is conflict of interest. It used to be so important the last 3-4 years. There was always a conflict of interest scenario question. But I've noticed that a lot of the exams in the last year or so, just because people have been focusing on conflict of interest, the NCA has moved away from making sure it's in every exam. So it's not focused on anymore, but please note it because it's the more tricky part of Part B. Now the duty under IRAC, there are duties that you owe, that a client or a lawyer owes to their client, right? And under IRAC, IRAC is like locus classicus, something that you should actually read. Go read the IRAC case and pick out those parts of interest inside the case or inside the particular case. Now, when I try to explain ethics or professional responsibility, I try to explain the fact that it starts from a fiduciary relationship that is owed to the client. So as a lawyer, as a professional, as a self-regulated profession, we owe a fiduciary relationship to our clients. So knowing about our clients and knowing about their information they're giving us all this information because they want us to help them. Okay. And in understanding the fact that you have a fiduciary relationship, it creates a duty of loyalty to your client. And this is also seen in the R&Neo case, right? So it creates a duty of loyalty to your client. And in having this duty of loyalty to your client, the duty of loyalty is broken into 3 different C's. They call them the 3 C's. The first duty of loyalty, it's broken down into 3 duties, the 3 C's. Now, so loyalty to your client can be seen as the duty of commitment to your client's cause, which is the first C, commitment to your client's cause. The duty of confidentiality, right, which is the second C, and the duty of candor, which is the third C. Now, candor is like a duty of honesty, that you have to be candid to your clients. You have to tell them the truth. This counteracts the dominant model. So I remember Success was asking about when do they ask us questions about the dominant model. So they don't specifically ask about the dominant model, but obviously if you're going to talk about the duty of candor or the duty of being candid, you have to be honest and candid with your client. So your client comes to you and says, I need to get this done. I want you to get this done for me. These are the ways I want you to get it done. And you see that, the system and the maps, the map out that they've given you will not work. It's your obligation as a lawyer in Canada to be candid with your client and tell them, no, it's not going to work. Honestly, this is how I see that this, and this, and this, and this. I know that this is what you want me to do, but I have to be honest and candid with you and direct you and tell you that as a lawyer, these are the things I think will work. And maybe what you wanted to do, we can modify a bit. You don't just take your client's direction, hook, line, and sinker. Okay, so you can now bring in the dominant model here and say, unlike the dominant model where the client is in charge and everything the client says is what you're supposed to do, we now owe an obligation or a duty of candor to our clients to be honest and to be candid and to tell them the truth at all times and to try and lead them and steer them and direct them in the way that we think that will work. Okay, now under the duty of commitment to your client's cause, you can put in the duty of avoidance, duty to avoid conflict of interest. So the duty here, like when people are doing the exams, they're just like, oh yeah, I can see that there's conflict of interest. No, what you're actually seeing is a breach of the duty to avoid conflict of interest, not just conflict of interest, right? So the duty itself is a duty to avoid conflict of interest. And I think we all understand what conflict of interest is. That's when the activities you're about to undertake or the activities you're about to go ahead and do for your client conflicts with something else that you are doing for someone else, another client. So under the duty of confidentiality, there are different parts or different people that you must be loyal to, right? You must be loyal to your former clients, loyal to your current clients, and loyal to your existing current client. So for example, you can have a conflict of interest between a former client and a present client. You can have a conflict of interest between 2 current existing clients. Okay? And obviously, when you discuss conflict of interest, you should always note what the cure is. There are always cures. So fine, there's a duty to avoid conflict of interest, but conflict of interest might arise. It's not impossible for it to arise. Conflict of interest should be reported immediately you notice that it has arisen. So you might, for example, have a client coming to you, you take on the client, and you don't realize that that client is going up against somebody that you have represented in the past. Okay, so obviously at the beginning of when you took the client, you didn't realize that there will be a conflict of interest. So the client mentions the fact that your former client is the person on the other side, or that they're opposing your former client. Then you realize there's a conflict of interest. At that point, you declare to your client that, oh, I believe there's a conflict of interest between me, you and this person. I would like to go ahead and still represent you. I don't think there's a problem. And there's a whole host of things that must be done. And we're going to deal with that in the intensive classes to make sure that you don't clash them up. But there's a whole host of things that should be done. First of all, like seeking the consent of both parties. If both parties tell you to go ahead, even though you have declared that there's a conflict of interest, then you can go ahead. And there's some other things that you have to check. Are they distinctly adverse? Do they have distinctly adverse obligations? Are both of them fighting over the same land? Is there an argument? Is there some dissent? Things like that. If there is an argument or they're directly adverse, then the law says that you cannot represent them. That's something called the bright line rule. So when discussing conflict of interest, you must mention the bright line rule. You must mention the substantive risk rule. Those are rules, they're a list of things that you have to check to make sure that the conflict, to make sure that you can go ahead. So the issue is you want to go ahead and represent this client, but you think there's a conflict. So you're looking at the list of things and checking them off. Okay, substantive risk rule, and checking off the things that, what do you call it, that would help you decide whether or not you can represent this client competently and adequately. So it takes us back to what we learned in part A about competence. Can I represent this client competently? Usually the cures to conflict of interest are seeking the consent of the clients, both clients or both people who are adversely affected, offering them independent legal advice. So you say, fine, I really want to represent you, but you can still go ahead and get independent legal advice with this matter. They might now say, no, don't worry, it's okay. Thank you for offering it, but we're fine with you representing us. Okay. And then you mention all the cases where these things have happened. So if you mention the bright line rule, you mention the case where it was decided or where it was created. The exceptions to the bright line rule, like fraud. Okay. You will not use the bright line rule as an instrument of fraud. For example, let me give you an example of when that can happen. If a conglomerate or a big company realizes that the bright line rule says that okay, let me give you what the definition of the bright line rule is before I go ahead to explain so that you don't get confused. Okay. It was held that concurrent representation of clients directly adverse in interest attracts a clear prohibition. So you're trying to say, I want to represent this client, but I see there's a conflict of interest, right? And then the clients give you consent to go ahead and represent both of them. Okay, now that's seen as concurrent representation. Okay, now the bright line rule is saying, fine, you want to go ahead and concurrently represent, but concurrent representation of clients directly adverse in interest creates a clear prohibition. You cannot, clear prohibition. You cannot represent these clients if they're directly adverse in interest. What does that mean? You want to buy land. One person is the buyer, one person is the seller, but there is a dispute. There is a direct adverse interest, right? So you cannot represent both clients, okay? Because the interests are directly adverse. For example, if we want to sell land, we both know that the land is $100,000. We want to go ahead with that sale. We have no issues ahead. Both of us give us consent to represent both of us. Represent me, represent the buyer, represent the seller. There's no adverse direct interest. You can go ahead and concurrently represent. Okay, so now, for example, you want to talk about the bright line rule. You first mentioned the case where it was decided. You mentioned the fact that it's, what do you call it, that they are not directly adverse in interest. Now, an exception is that the bright line rule, as I have just defined, cannot be used in an instance of fraud or cannot be used to hinder somebody else from accessing justice. Okay, now you're a big conglomerate company, right? And you go and put all the top 10 or top 20 law firms on retainer. And then there's a client, a small client that you have an issue with, and they try to use one of these law firms. And then you go ahead and say, because of the bright line rule, and we cannot directly adversely represent, then you cannot use any of the lawyers that I have hired. That is them trying to use the bright line rule for tactical abuse. Okay, they're trying to make sure that you don't get a good enough lawyer by putting the other 20 lawyers on retainer. The bright line rule will not function in that instance. So that's one of the exceptions of the bright line rule. So if you do talk about the bright line rule, you define it, talk about the case that where it was postulated, talk about the exceptions and list the exceptions. Most times there's an exception to a rule. Okay? So always mention, so when you're doing your analysis, those are the things you're mentioning. You're going to look at the concept. What concept are they talking about? This is the concept, this is the definition. Is it defined by the model code? You check whether its definition is in the model code. Are there any rules that apply to it in model code? You list those rules out. Are there any exceptions? You list the exceptions. Then what are the cures? Does the model code provide any cures? For example, conflict of interest. Yes, it does say that you should seek consent of both parties. Look for the rule that talks about consent. It does say that you should offer them alternate legal advice. Look at that. So when you're concluding from your own opinion. You're saying, well, in conclusion to this matter or to this concept, or in conclusion to what I have just discussed, I believe that this is an issue, an ethical issue. I believe that the lawyer can be found guilty of this if it's considered, but the lawyer can go ahead and cure. So this is the information the NCA is looking for. So as you're reading, you're picking up on concepts. What does the concept teach you? What is it saying? What does Canada say about it? What does model code say about it? Are there any cures? Are there any exceptions? That's the information. What are the cases that apply to it? What is the one line in the case? Why does this case apply to it? So like the Trinity Western case, I told you this is what they're looking at in PR. Why we're discussing this case in any fact. So you look at that particular case and say, okay, this is the major issue while we're looking at this case. And then you go ahead and conclude. So in your reading, this is how you're trying to gather information. This is what you're looking at when you're gathering the information and going through the notes and the syllabus. Okay? Let me go back to the syllabus so that we're not wasting time. So we've gone to conflict of interest. And basically, after conflict of interest, up onto access to justice, most of it is bullet points. Okay? When you talk about the dominant model, they're always talking about zealous representation. It's the same phrase that they use when they're talking about the dominant model. Zealous representation of your client. Zealous representation of your client is a phrase that's constantly used. Talking about zealous representation. I'm trying to look for the phrase that the lawyer for the Queen, the case I explained earlier, the lawyer for the Queen that brought up the dominant model of ethics. And I'm trying to see if I can say that, so at least you have that in your mind, but I can't find it right now. Oh yes, I found it. So the lawyer in that case was called Henry Brougham. You see him in your notes and in your textbook. And in defense of Queen Caroline against adultery charges brought by her husband, King George IV, he famously argued that a lawyer knows but one person in all the world, and that person is his client. A lawyer knows but one person in the world, and that person is his client. So basically, the statement that they use when they're explaining the dominant model of ethics. And that's the statement they use when they're talking about zealous representation of your client. What is the word zealous? When you're a zealot, like for a religion, you are just pursuing the objects of that religion diligently with no other thoughts in mind, pursuing the objectives of that religion. So zealous representation of your client is without considering anything else. You're zealously following through on the representation of your client, getting the objectives of your client, bringing them to pass. Okay. So it goes on to the fourth part of Part B, talks about the adversary system and lawyers as advocates. Okay. And the issues to consider here are the adversary system and its impact on professional obligations, lawyers as advocates, lawyers as counselors. So if you have your notes, you notice that there are bullet points. What should a lawyer do as an advocate? What should a lawyer do as a counselor? This isn't really difficult. Once you have the bullet points, it's an open book exam. If they ask you anything in relation to this, just go and pick out your bullet points and explain them. They're not anything difficult. You should have a good relationship with other lawyers. You should be diligent. You should be competent and diligent in carrying out services for your clients. I talked about candor. When I say you must be candid and honest with your client, zealous representation, duties to clients, opposing counsel, and court and other parties. So you don't only have a duty to your client, like I mentioned in the dominant model. You have a duty to opposing counsel, you have a duty to the court, and you have a duty to other parties and the society. So when Trevor C. Farrow was talking about sustainable model and the fact that there are other things to consider, these are the other things to consider when you're talking about carrying out your services as a competent lawyer, as an ethical lawyer. Your duty to your client, formation of the contract or formation of your client relationship, being confidential, making sure there's no conflict of interest, making sure you represent them to the best of your ability. Duties to opposing counsel, they must be treated with respect. You will not fight with an opposing counsel just because you're representing another client in an opposing client in court. Duty to the court is that you would be respectful. You would speak courteously, things like that. Other parties and the society. So these are the things that you're considering when you're an advocate. You're not just considering the client or just yourself. Then they talk about civility, which I've talked about when talking about relating to the court and counsel. Document production. Document production has to deal with the fact that it doesn't matter whether a document is going to prove your client guilty or show that your client is liable. Once you've gathered information and you've gathered a list of documents, for example, you do need to produce that information to the court. It's now up to the court whether to say that they want to look at it, or even if the information is confidential, for example, it should still be on your list. So it's not the duty of the court to say, oh, we want to unseal it. We are going to request for that information specifically. You can't say because something is going to be detrimental to your client, you won't produce that document. As a official of justice, as an officer of justice, and in efforts to make sure that there's justice passed out in society, you do need to do some things like produce documents, even if you feel it's negative for you. So trial tactics, evidence and disclosure, witness preparation, conduct and perjury, all of this are, I feel, bullet pointed, and it tells you what exactly you need to do. It's a list of things that you must abide by. Okay, when you're reading this in your notes, make sure that you're also counter reading it in the model code. If they say open rule 7.2, open rule 7.2, read what the rule says as you're reading your notes as well. It's going to help you so that when you're responding with that particular section in the exams, you know what rule is applicable to it and why it's applicable to it. Okay. Specific areas as well, like I said, going on. The rest of the syllabus is basically bullet points. It's telling you exactly what they think you need to do in those situations. Is there a difference between, from an ethical perspective, between the various practice areas and context? Should there be? There's no difference between the ethical perspective between various practice areas. It's just that in various practice areas, there are different requirements of the lawyer. For example, when you are working with a law firm, right? You have many clients. It's your law firm or you work with a law firm. You have many clients. Many people are paying you. So basically, you are not beholden to anybody in particular. If there's conflict, you can just pull out. If there's breach of conflict of interest, you can pull out from representing that client, right? Now, if you're working as a lawyer in an organization, totally different. You have one client. You can't just pull out from representing that client because that is your whole livelihood, right? So your reaction will be slightly different if you're a consultant or you're working in a law firm, which is when I said that you must note the word that reporting up the ladder. If you're an organizational lawyer, you do have to report up the ladder. That's the only way you can actually refrain or pull yourself out of that relationship. So if there's anything fraudulent going on and you are informed of it, you can't just say something fraudulent is going on, I'm not representing you anymore, and stop going to work. You first relate with the person closest to you, the person that you relate with the most in the company, which is probably the chief legal officer, the CLO. You report the issue of fraud to them. You tell them to please go ahead and cure the issue. There's an issue at hand. That person doesn't respond to you. The law says, well, we know we don't want to cancel your, what do you call it, income stream. Go ahead and report to the CEO. Don't just cancel your terminate your employment. So you report up the ladder to the CEO, tell the person of the fraud isn't cured, you wait a bit again, give it some time, you see that there's still an issue, you report to the board. Because the problem is, if you are not doing this and you're letting them perpetrate the fraud or this activity, you can lose your license. And in a bid not to lose your license, in a bid not to be the one that's at a detriment, you can then say, I've reported to the CLO, I've reported to the CEO, I'm just carrying it out, as the model code says, I'm reporting up the ladder. The third parties to report to are the board. The CEO didn't rectify the issue, report to the board. It's at this juncture, if the board goes ahead and ignores what you have given them or what you've told them, you can then refrain and pull yourself out of that relationship and say, I'm no longer representing this client, and look for a new job. Totally different from if you're a law firm. The instant you find out that your client is being fraudulent, you terminate the relationship. You just say, well, because there's a rule in the model code that says that you should not be used as an instrument of dupe, which means the commentaries explain that anytime you see a red flag as a lawyer, it's your duty and obligation to ensure that they're not duping you, they're not carrying out anything fraudulent. So there was a lawyer in Alberta recently, towards the end of last year. Her mortgage clients were using the mortgage or the money used for the mortgage, they were getting it from illegal sources. She was totally unaware. The law says that she was unaware of what was going on, but because she was the lawyer on the transaction, she was suspended for 3 months from her practice. Her practice was handed over to somebody else to carry out for the 3 months. So the model code here in Canada says you shall not be used as an instrument of dupe. Once you see a red flag, you must do all your research. You must ensure that you find out what is going on. And if you see anything dubious, slightly dubious, you pull out. You do not stay on as a representation or representative of that client. Okay. So it goes on to ethics and dispute resolution. It talks about counseling and negotiation. And here they're asking you, when does a lawyer-client relationship come into existence? It talks about lawyer as a negotiator and mediator. Let me see if I can find some of that. Negotiator and mediator talks about how you should handle your client when they're negotiating, how you should handle your client during negotiations. You shouldn't force them to do anything that they don't want to do. You shouldn't force them to commit any fraud. You shouldn't what do you call it? You shouldn't make your client or negotiate. If you find out that there is an amicable solution to the issue at hand, you are obligated to propose it to your client. Okay? You're not expected to say, oh, we want more money. Maybe we have 400,000 and everybody's agreeing to that 400,000. But you think that if you keep on pushing, you should be able to get $1 million for your client. It's not your obligation as a lawyer to do that. Once you're able to find an amicable out during negotiations, you have to push your client to go ahead and take that route or take that amicable decision. You should look at why counseling is different from negotiation. Counseling a client is when you're trying to, for example, your client is going into court and they're going to talk, or is going for a matter, is going for a negotiation, or is going to discuss with somebody in another party, maybe sale of land. Okay, you do not go ahead and teach them what to say. You can be candid, you can be honest and candid and tell them, honestly, this is what I believe. But you do not go ahead and try and teach them and tutor them through what to say for it. When you have made an error, for example, if you have given wrong advice, the instant you find out that there is wrong advice, you are obligated to let your client know that you have given them wrong advice. They should go and seek alternate legal advice, or this is the solution that they need to go through now that you have told them that you have given them wrong advice, right? You must be candid and honest in your communication with this client. And your role as a counselor is totally different from your role as an advocate. When you're an advocate, you're dealing with, we're going into a court matter, these are the pleadings, this is what we need to do for cross-examination, basically the things that are going to happen in court. But when you're a counselor, you may interpret the information. For example, they're going to, you're reading a contract for a client, so you're counseling them on the actions that they need to take with regard to that contract, okay? Or it's possible that you are reading through one of their sales decisions and you're giving them advice. Now, whenever you're counseling a client, you have to differentiate between legal counsel and business counsel. So when you're giving them legal counsel, you must point that out and you must let them know. And when you're giving them business counsel, you should also let them know this is just business advice, has nothing to do with the legal aspects. Okay. You should also realize that because there's a fiduciary relationship, there's an uneven power balance between you and your client. So they might take your word as law. You understand? Because they believe, oh, you're the lawyer and you're in charge and you know what you're saying. You should realize that there's that uneven power balance. They're not skilled. Your client isn't skilled. If they were skilled, they won't come to you to ask for your advice. So you must always be mindful and ensure that your client makes a decision on the basis of the advice given to them, right? With regard to the legal options, they don't know, so it's up to you. Now, this is also different from negotiation. When you're counseling, you have to be honest and candid, right? But when you're negotiating, you're allowed to give some form of bluffing and non-disclosure. It's like an art. So you know that, for example, we're trying to sell land, and it's not up to me to be honest and candid in this situation because I'm trying to get the best deal for my client. So in instances of negotiation, you can bluff or not disclose everything that you would need at that point. Ordinarily, when you're representing a client, you know, we talked about document disclosure and all of that. That is required, but under negotiation, there's a loophole that says that you can go through a bit of bluffing and non-disclosure, and there are a few cases that explain how that should be done and when that should be done. Okay. And then there's competency, confidentiality, conflict of interest, disclosure and obligation, lies, misrepresentation. So what I just talked about comes under lies, misrepresentation, and misleading truths. Is there a difference? You have to know the difference. Which one is bluffing? Which one is an outright lie? Which one is a misleading truth? Okay. And then, of course, it goes to ethics and the practice of criminal law. Tells you how to be a good criminal lawyer, what you're expected to do. Specific bullet points on this is what you should do and this is what you shouldn't do. We've talked about lawyers in an organization setting. So if you're a corporate counsel, usually the most important aspect there is reporting up the ladder, document protection. The client is the organization, not the officials. And then government lawyers, what is expected of you as a government lawyer? There's a high level of expectation from government lawyers because you are representing the Crown. So the Crown Counsel and prosecutors, what they need to do, how they need to rely on justice. You can't keep pursuing something if it's not seen as a matter of justice. You can't keep, because it's a criminal, not looking at justice or social construct. You have to actually focus on those things and make sure that you're representing the Crown well. You're not just being negative to the criminal person that you claim is a criminal or the person that you feel has done something wrong. You still have to be balanced and neutral in your representation of the client. Okay. Are there any questions so far? Is everybody good? I've been talking for a bit. No? Yes? Okay. And the last part is part D, access to justice. The first thing you should note with access to justice is that there is limited access to justice in Canada. That's the most important sentence in this part. There's limited access to justice in Canada. So this part actually looks at access to legal services, who should pay, the clients or their lawyers, what are their problems and possible solutions. So there's a whole section there that talks about, the UK had issues of access to justice, and this is how they went about it. These are the solutions they came up with. And since Canada has issues with access to justice, what is being done as solutions to this to create more access? So that's where they talk about legal aid, pro bono obligations, community clinics, legal fees. Is it high legal fees? Is that what's chasing people away? Should we lower legal fees? Are we taxing legal fees? Are we putting more taxes on people that are seeking legal resolutions? What is legal insurance? What are paid legal regimes? What are the regimes that exist in Canada at the moment, the different types, because there are different types of legal insurance. Paralegals, class actions, who are paralegals right now? Is that a solution to access to justice? And that's yes. If people can't afford a full-time lawyer, there's some activities that paralegals can carry out. So I know that some people's short-term goal, before they finish their requalification, they qualify as paralegals because there's services that paralegals are allowed legally to offer to society, and they're not as expensive as lawyers themselves. And then class actions, instead of bringing an individual action, bringing a class action is a money-saving solution to access to justice, coming together as a group and bringing a class action. And that is a summary of the syllabus. The rest of the syllabus from page 12 is the Groya case and the Trinity Western case, which I explained that you should read with relation to PR. They added this part to the syllabus to make sure that you're not reading the full case and you're just getting the information that you require from the cases themselves. So does everybody know how to download the model code and download you all have your syllabuses, the model code, and your notes? Is anybody that has issues with that? Because the model, the syllabus is on nca.legal. You can go to outlines, schedules and outlines, and download the PR syllabus from there. We're still using the August 2019 as of today. If there's an update, we'll be using the updated one for the intensive classes. The model code is also online. It's free for download. Like I advised at the beginning, please run through the model code. Don't make notes. Just read through it like a book. Just read through so they are aware of most of the rules that are there. By the time you're reading your notes, then it's easy to tie in the rules to the parts of the notes that you're reading. Do I have any questions, or does anybody have any questions so far?
I wanted to clarify something. So you know how you're talking about how like when there's conflict of interest, there's always a cure, right? So I wanted to give this example to see if that's also a cure. So in the firm that I work in, right? So the department I work in as legal assistant for is child protection. So one of the lawyers that I'm working with now, she used to be on the other side, like she used to be parents counsel. But now she's working with us, so she's the director's counsel. So one of the files we had, the father of that child, she had represented before in another matter, but then now we have the file. So what she did was she said, oh, because of conflict, I cannot appear for the director in this file. And then she gave the file to another lawyer in the office. So whatever communication that was coming, like I was copied in the emails, but like she was not copied. They were not telling her about it. Like, so that was how we're able to still handle that file. So that's a way to cure conflict, right? Like, so in a law firm, some other lawyer can handle the matter.
So in the intensive classes, we're going to go really in depth. It's a 4-week class, 4-week class, and we actually spend quite a lot of time on conflict of interest. So when I was explaining conflict of interest, I remember mentioning that there's conflict between former and present clients, conflict between current clients, right?
Mm-hmm.
So if we go to, I've opened the modal code now. 3.4, rule 3.4, I believe covers conflict of interest. And I'm going to try and rush over there right now. Conflict of interest is, first of all, I'm going to get to where you're going, so I'm just going to go systematically, right? And it'll answer your question. Conflict of interest is one of the concepts that's defined in part 1, rule 1. You know, I said there's a definition section at the beginning of the model code. So always note that it's defined, so you can actually use the definition from there. Now, rule 3.4 talks about conflicts of interest. And the only rule in 3.4-1 is a lawyer must not act or continue to act for a client where there's a conflict of interest except as permitted under this code. Obviously, that is general and vague. So you have so many commentaries to explain what these conflict of interest areas are. And like I said we'll refer to this later. When I explained the sexual relationship one, where I said the rule itself says shall not continue to act for a client where there's conflict of interest. It's until you get to commentary 11 that you notice that a lawyer has a sexual or close relationship with a client is one of the things that can raise conflict. Okay, that's something I think a few people miss. And usually there's a question and you see a relationship, it doesn't strike you as conflict of interest at that point. Okay, now what you are talking about is conflict of interest between former client and current client. This happens often, right, in Canada because of articling. So yours is even that an associate was somewhere else and came to your firm. Usually it happens mostly when an articling student articles for a year or 10 months or whatever, and then after articling goes to start their career in a law firm, right? A lot of the time they have clients or former clients from the old firm, and obviously any issue that can arise is a conflict. Okay, now if it was a one-on-one, I own my own law firm and I'm representing, and they bring a matter like that to me, I can't represent the new client because there's conflict, right? But because they know that it's almost impossible for that to happen with a firm, it means you're taking a lot of their revenue by saying that none of the people who've represented people in other firms can also represent people here. Okay, so now there's a whole section in the model code that pertains to representation of a former client if you're a firm, and that's a cure, right? And this section, it's called guidelines. So the first cure is consent, 3.4-2. You seek the consent, and this explains everything about consent, direct consent, implied consent, all of that, right? Disclosure and consent. Like I said, the professional responsibility isn't trying to say you made a mistake, we're going to take you to the ethics committee, you're going to be disciplined for it. No, it's always, the model code always allows you to cure and correct that issue, right? Now, so we've looked at consent. Consent is one of the corrections of that issue. But in this instance, because it's a law firm, right, consent might not be adequate, right? Because she has information from the past matter and there's no way, she's human. Any information she has, even though it's confidential, it would affect her actions. She already knows the information, so her own actions are going to be affected and she won't be neutral or unbiased anymore because she already has information from the other party. So the model code has created something called, okay, we talked about concurrent representation, joint retainers, that's when they agree for you to represent them both, which is concurrent. Then acting against former clients is what you're talking about. There's a set of guidelines, right? I think it's 3.4-20, if I'm correct. Law firm disqualification. So if a transferring lawyer actually possesses confidential information relevant to a matter respecting respecting the former client that may prejudice the former client if disclosed to a member of the new law firm. The new law firm must cease its representation of its client in a matter unless the former client consents to the new law firm's continued representation of its clients, which is the first cure, consent, or the new firm has taken reasonable measures to ensure that there will be no disclosure of the former client's confidential information by the transferring lawyer, and advise the lawyer's former client. Okay, they always have to advise the former client of the steps that they're taking, right? Now, it's not just random steps. The model code actually specifically gives you commentary 3, guidelines, how to screen / measures to be taken. Okay, so we found out that this person has worked on the other side with the other party. This person is now in our firm. We really want to take on this new client. What do we need to do? So you come here. The screened lawyer, which is your colleague, should not have any involvement in the law firm's representation of its client's matter. The screened lawyer should not discuss the current matter with any information relating to the representation of the former client. So she must not talk to anybody in the parent firm about the old matter. No member of the new firm should discuss the current matter with this lady. The firm should take steps to preclude the screened lawyer, she's the screened lawyer, from having access to any part of the file. So that's when they lock it in a file cabinet, somebody has the key, it's a particular legal assistant in charge. The new law firm should document the measures taken to screen the transferring lawyer. You have to document this. Why are you documenting it? You're documenting it because, where are we? You have to advise the lawyer's former client of all the steps that have been taken. So after they set up all these steps, right, they now document it and send it to that former client and say, we've made sure that all of this happens. She doesn't touch the file. She's not discussing with the client. Somebody else is handling the matter. She's not involved. She hasn't disclosed anything. You understand? So we have documented this so that you're at rest and you're at peace and none of your information has been shared. This is a second cure. But this is only applicable when it's a law firm and it's a former client to a current client relationship, right?
Right.
Different from the other one where it's just seek for consent and alternate legal advice, right? But obviously, you're going to come across this when you're reading and go through that. So yeah, that was a really great question. I didn't touch on it because of time and all of that.
No worries. Thank you.
But we'll definitely have to deal with it in intensive classes and discuss it in detail. Okay. So yeah, like I said, if you do read the model code, like what I just read to you was directly from the model code, read it like a storybook. You get all the information at once. It's like an overload. Then you go to your notes and then you're now detailing the information. Okay, under chapter 1, this part of the model code applies. Under chapter 2, this part of the model code applies. Am I allowed to borrow money to my client? So I saw that in the model code a few when I was reading it. What do the notes say about it? And you're documenting, but you've already read the code, so you're aware of what the code kind of says. And because you haven't practiced in Canada before, these rules are new to you. So this is the best way for you to kind of get yourself acclimatized with the new rules before you do the exam or before you read the notes. Okay. So we've been through the whole syllabus. I've looked through the commentaries to kind of explain to you. We do have the professional responsibility course is a 4-week course. It holds at this exact time every day for the next, I think it starts in 2 weeks time for the next 4 classes. The 5th class is an exam preparation workshop. So even if you do not join the professional, hold on a second, please. Apologies. Okay, let me stop sharing. So even if you don't join the intensive classes, it would be beneficial to join the exam workshop. So read and then come to the exam workshop, and then we can actually structure how the exams are expected, how the information is expected to be arranged in the exams. I know that a lot of people don't have time. Most people are working full time, which is where the classes come in handy. I can break down the concepts for you, explain the concepts to you, tell you what to focus on. We can discuss the cases. Another thing is once you've discussed something in class, it's a case you remember. You don't have to go back and actually read it. We talked about the facts. We talked about what's important in that case and how to apply it. For those who are joining the intensive class, the exam workshop is part of the intensive classes. And I think you get a 50% discount on the NCA Guides index. I haven't talked about the index at all. So what we noticed when we were planning the schedule and the syllabus for the Canadian Professional Responsibility, and quite a few of us actually used the first versions of the index during our exams, I think 2-3 years ago, is that with the model code, let me reshare. It's it doesn't specify the rules. Okay, so I'm back to sharing. So if you go to the beginning of the model code, it doesn't specify what rules, and it's a time, we're trying to save time. The NCA exams are more about a time saving, it's a timed exam. And we've learned that a lot of it, they know that you are a lawyer. They know that you already have this information. They already know that most of us are practicing or were practicing. So basically, it's getting you to finish the exam under that high constraint of time is the problem. And they've already distracted you by telling you it's an open book exam. So most people spend time opening their books, looking for the information and losing time and not doing the exam within the allotted time. Now, what we noticed is the index for the model code, the official index, this is what it looks like, right? It's 3.1, 3.2, 3.3. It gives you the topics, right, for what's in the model code. Now, if you're in an exam and you're looking for information, you go to 3.2, quality of service, dishonesty and fraud. You're going to have to open page 24 to go and look for dishonesty and fraud and whatever the information is that you're looking for, which is wasting your time. So what the NCA Guides did is we created a code. Let me see if I can share that. Do I have it open? We created an index that would help you. Yes, there it is. We created an index that would help you with with your exams. So this is the NCA Guides index to the model code. And what we've done with this index is we've pulled out all the rules at the first 9 pages of the index. So unlike what you just saw in the official model code index, here we have 3.1, 3.1-1, competent lawyer definition and requirements. You know exactly what's there. 3.1-2, lawyer must perform all legal services for client standard or competent lawyer, right? 3.1-2, quality of service is required. 3.1-2A, advice about nature, extent. So you understand what I mean? We've actually pulled out the rules to the first 9 pages of the index so that as you're going through your exam, you're trying to remember what rule applies. Dishonesty and fraud by clients or others, which I just mentioned in the model code, is actually 3.4-7, which isn't in the model code index. And what it says is a lawyer must not knowingly assist or encourage any dishonesty, fraud, or crime or illegal conduct. I mentioned that you should not be used as an instrument of dupe when we're talking in the exam just now. So this helps in that when you get to the rules section of your exams, you're easily able to pull out the rules that you need to populate the rules section and quickly go on to your analysis. Okay. And then after the first 9 pages, which is just basically the rules themselves, so 3.4-12, 3.12-15, and it gives you paraphrases. The NCA tells you not to write exactly what the rule says. They don't give you marks for writing what it says. But we've paraphrased what that rule says over here so that you can actually state it in this fashion. You can write it like this in your exams. It's not exactly what the model code says. It's just inferring what that rule is talking about, right? And then after we finished the first 9 pages, which was basically just the rules, then we now went on to expanding the code. So when we now expanded the code, I came up with, for example, I know that competence is an important concept. right, in professional responsibility. I pulled out the important commentaries under competence, not everything, so just 1, 7A, 7B, and 14. And I also gave additional notes. Additional notes, a lawyer can take a case which he does not have competence, or a lawyer cannot take a case which he does not have competence. This is a case that applies to that sentence. The highlighted cases in this area: Central, Trustco, and Refuse, Nova Scotia barristers. I've pulled out the information and what was held, what's important for these cases in application to competence. I think I did that under confidentiality and conflict of interest as well. So the important commentaries, I remember I mentioned that there were exceptions when we're talking about confidentiality. Crime and fraud, public safety exception, that's the case. Anyway, so the NCA guys has put together this to help you with the exams. It's an exam tool. Wouldn't really help you while you're reading and studying and gaining information, but once you start to prepare for the exams themselves and you already have the information in your head, then this is actually helpful on the exam day itself for you to actually pull out the information and move it over to your typed screen. I would have said move it over to your sheets, but right now the exams are online. So highlight cases, additional exceptions, and information that I know that you would definitely need and would give you marks, because the marks in the NCAs are, 2 marks here, 3 marks here, 4 marks here. They don't give you marks as a bulk. It's when you mention all these little things that you get the marks for them. So our intensive class students get 50% off this index, get to attend the exam workshop classes and the 4 weeks intensive class, okay? If you are not joining the intensive classes, then you can pay to join the exam workshop, which would be in 5 weeks' time in preparation for the exams. And then you can also purchase the index online on the website, help with your exams. I think those are all the things I wanted to cover, or that's basically the overview for the course. Please look at the issues in your syllabus. Make sure you look at those issues after you read each section and answer the questions. If you have time, I would say do a paragraph or answer the questions and write them out, so that when you're in the exams, if you get a question with regards to that area, you just look at what you've already written and you lift. That's another time-saving a tip. So you just leave that paragraph on. If they ask about professionalism, you already have your definition for profession. You have a list of things that a profession will do. It's already written there, you just lift. If you have someone like Manuel's notes as well, you highlight. So you already know what you're going to copy. You know what points you're going to list for that section. Do we have any questions? We spent about an hour, 2.5 hours right now. Yewi, Rashima, Lyle, is everybody fine? Abby?
Yes, fine so far.
I'm fine, thank you.
Fantastic.
Yeah, I think I'm fine. I think what I really need now is getting something like an index, because I've been worried about information overload and turning pages during the exam.
Yes. So the way the index is structured, although you have notes and textbooks and the syllabus,
Waste time
you
moving
will
from page
waste
to page.
time. You will
I
waste time.
realized that I was talking to a friend yesterday. I'm like, how do we do this thing? Because if I keep going from index to syllabus to notes to, before you know it, you spent
Time is gone.
Yes.
So in the end, well, with my past candidates, I would say you end up using your syllabus and the index. So what happens is you read a question, you run through the syllabus to check what concept they're asking about, because it's really a concept. They want to, for PR, they want to make sure that you understand that concept. You understand the concept. Are there any exceptions? What are the rules relating to that concept? What is your conclusion? Okay. So basically, you go through the syllabus to say, okay, fine, I read the question. This is what they're asking about, chapter 4, right? And this concept in chapter 4 is what? Competence, quality of service, confidentiality. You run to the first 9 pages of your index. What rules apply? Let me see. What rules apply to what I'm about to write? So this one here. Sorry. Okay, so you now run to the first part of your index, right? And say, okay, fine, even if you haven't read completely, right? And they're asking you a question. And you're like, okay, fine. It looks like they're talking about lawyer and an organization. Then you scroll through, you actually look for lawyer and an organization in the index, right? Action of former clients, law firm disqualification, transferring lawyer. You understand? You are quickly scanning through this index to see what is said about that particular thing. So, for example, if they say withdrawal, you see that somebody's canceling their representation. You go to 3.7 withdrawal for representation. Automatically, you can see 3.7-1, put that in your rule section. 3.7-2, put that in your rule section. Talk about, it talks about optional withdrawal from representation. If they say anything about non-payment of fees, they're obviously referring to 3.7-3. You understand what I mean? So you don't have to go into the code or your notes. This is already telling you what the topics are about and which rules are applicable. And by reading the rule, before agreeing to represent a client, the successor lawyer must be satisfied that the former lawyer has no, you understand, this is already you explaining. All you have to do is explain what this sentence says. So that's like time saving towards your exam. And then it's after you, and luckily you're typing. So it's after you've gone through all of this and you feel that, you need to add more flesh, right? Then I can say, go back and open your notes to a specific thing and just try to lift. But at first, you've already put in your structure, you've put in your rule, you've put in your analysis, and you've concluded, and then you can go in and fill in and add more flesh to it. So I would say that the index is effective. I know that most of us on the NCA guides actually used this before it became this document. The early starts of it, we used this for exams, and it was very useful. It really helped us save time. Okay, so I would like to say thank you guys so much for attending this class. I know it's hard for you to squeeze out time of your busy days to join class. My email address is funto, Funto, @ncaguides.com. I think I sent you an email for the class from there. If you need to contact me with questions or you have anything that you would like to clarify, please send me an email.
We are NCA Guides.
Every year, a significant number of foreign-trained lawyers immigrate to Canada, and hundreds of Canadian citizens return to Canada after obtaining law degrees abroad.
Upon returning to Canada, they have to get their credentials assessed by the NCAs and write several equivalency exams before being eligible to be admitted to any of the respective provincial bars.
The NCA exams are examinations very similar to those taken in the Canadian law schools. They're fact-based and open book examinations that take 4 hours to write. They're currently administered online.
These exams, which are graded on a pass or fail basis, are done without any help of the NCA. This is where we come in.
I have written and passed the Canadian Administrative Law exams.
I have taken and passed the Canadian Professional Responsibility examinations.
I have written and passed the Canadian Criminal Law examinations.
I have written and passed the Canadian Constitutional Law examination.
I have written and passed the Foundations of Canadian Law examination. We have all been through these examinations. We understand the difficulty that the NCA examinations present, and we help candidates overcome these difficulties and obstacles in understanding the course materials and the exam formats.
We do this through intensive classes, revisions, spot tests, and exam review workshops. We do not believe in a one-size-fits-all approach. Our study sessions are focused on helping candidates understand the course materials in a way unique and personal to achieving their study goals.
We have a great track record and excellent results from our past and present candidates. If you're writing the NCA exams and you want to pass them all at your first attempt, join our classes today.